This educational video will cover small claims in Kentucky. We will discuss topics such as what small claims court is, how to navigate the court process, and what else you should consider before beginning the small claims court process. Small claims court is a division of the district court that decides disputes between two parties. If you are the party suing another person or business, you are the plaintiff. If another business or person is suing you, you are the defendant. The maximum amount of money that a judge can award in small claims court is $1,500. You may sue someone for more than this amount, but in small claims court, this is the most that you may recover. If your claim is worth more than $1,500, you may take your case to district court. However, taking your case to district court is more complicated, and it is suggested that you hire an attorney before taking this route. Before filing a suit in small claims court, you should also consider the defendant's ability to pay. Some defendants are judgment-proof, which means that they have little or no income or property. If the defendant is judgment-proof, then collecting your award may be postponed until the defendant has the ability to pay. A small claims court judge cannot hear every type of claim. The following claims cannot be pursued in small claims court: criminal actions, causes of libel, slander, or defamation, malicious prosecution, and abuse of process. Also, it is important to note that individuals are only allowed to bring a maximum of 25 small claims cases a year. Often the most important question you have to ask yourself is whether small claims court is the right place to resolve your problem. Small claims court can only offer money as a solution to your problem. The judge cannot make the other side apologize for what they have done, and you are not guaranteed to win your claim. You are only guaranteed to have your claim heard in a court of law. Other things to be considered are whether the other side will hire an attorney, countersue you, or try to move the action into the regular civil division of district court. If you decide small claims court is right for you, you will need to complete the following steps to get your claim started. First, you will need to fill out the small claims court complaint. This form is available online at kyjustice.org, or you can pick it up at your county's district court clerk's office. When filling out this form, remember that you are the plaintiff. Be sure to include both yours and the defendant's correct addresses. The clerk cannot help you fill out this form. Once you have correctly filled out your complaint, you will need to file it at your district court clerk's office and pay the filing fee. When filling out the claim portion of the complaint, you need not tell every detail of how and why you are bringing your claim. You only need to briefly describe how the defendant has harmed you or your property, and the amount of money it cost you. On your court date, you can tell the judge the other details that you feel are necessary to supporting your claim, but on the written complaint, keep it brief. In addition to the complaint, you must also fill out a summons. The summons lets the defendant know that the legal proceeding has been started against them and that a file has been started in the court records. This form is also available online and at the courthouse. And after you complete the form, you need to serve your complaint and summons on the defendant either by certified mail or by sheriff delivery. At this point, you have successfully filed your claim and delivered your summons, and you will finally have your day in court. On your court date, make sure you do the following. First, arrive on time and dressed as if you were going to a job interview or church. Second, always address the judge as your honor. Speak only to the judge, not to your opponent. Never use profanity of any kind or show disrespect to anyone in the courtroom. Third, be organized. Bring any and all paperwork that supports your claim, such as canceled checks, damage estimates, contracts, letters, or any other documentation that supports your claim. It is best to keep all of this paperwork in a folder. On your first day in court, if both parties are present, the judge may order you to participate in mediation. Mediation is a non-binding conference between you and the other party that is designed to help both parties come to a settlement agreement. However, if you and the other party are unable to reach a settlement in mediation, you will be given a new trial date to state your claim before a judge. You will not have a jury trial in small claims court. The judge will decide the outcome of your claim. At your new trial date, be sure to bring an organized folder that contains all of your documents that support your claim. You should also bring any witnesses that you feel you may need to prove your case. If you missed your first court date, the judge likely dismissed your claim. You are allowed to bring your claim again, but you will have to repeat the filing process and again pay the filing fees. You should contact the clerk's office to see what happened on the day you missed. It is possible that the judge found against you if the other party was present and filed a counterclaim. If you show up on your court date and the defendant does not, you may be able to request a default judgment. A default judgment awards you what you asked for in your complaint. You will still have to present your case to the judge, who will ultimately decide whether or not to grant you a default judgment. If on your court date the judge rules in your favor, congratulations, you have won your case. However, the process does not end there. At your hearing, the judge will tell you who won, how much is to be paid to you, and how it is to be paid. The judge will give you a court order entitling you to receive the money awarded to you by the court. The losing party has 10 days after the stated due date to pay you your award. If the defendant fails to pay you within the time frame allotted by the judge, you will need to go through a special process called the post-judgment collection procedure. You may also be able to garnish the defendant's bank account or a part of the defendant's wages if they have a job. This process requires that you follow specific procedures, so be sure to follow the court clerk's instructions. If you lost your claim, you can appeal, but you have to do so within 10 days of the judge's decision. However, the appeals process is expensive, complicated, and time-consuming. Should you decide to further pursue your action through the appeals process, it is highly recommended that you consult with a private attorney. Before filing your claim, you need to know that there is a chance that the other side will hire an attorney, move the case to district court, or file a counterclaim against you. If the other side pursues those options, there is nothing you can do to prevent it, so just be prepared. If the defendant files a counterclaim, the judge will hear their claim at the same time they hear yours. You should carefully evaluate their claim and plan your response. If the defendant counterclaims, the incentive to settle your claim in mediation increases. The outcome of the trial could end up being worse than you initially expected because you could lose your initial claim and also lose the counterclaim that the defendant brought against you. Again, these are all things you need to consider before you start your small claims case. This concludes our video on the small claims court process. Should you have additional questions, please contact your local legal aid office or visit our website at kyjustice.org.